Good evening. Today I'll be talking about one of the fundamental requirements for the patent protection, namely the non obviousness requirement, also known as the inventive step. While novelty and utility are essential conditions, non obviousness plays a pivotal role in ensuring that patents are granted only for the inventions that reflects genuine intellectual and technical advancements. In this video, I'll be talking about meaning of non-obviousness, its statutory basis under the Indian patent laws, the rationale behind the requirements, the judicial tests applied to assess non-obviousness, and the important judicial precedents. Now let's talk about the meaning of non-obviousness. Non-obviousness refers to the requirement that an invention must not be apparent to a person skilled in the relevant art. The standard applied is that a hypothetical person skilled in the art who possesses ordinary technical knowledge but lacks the inventive ingenuity. If such a person can arrive at the invention without any creative effort by using prior art, the invention is regarded as obvious and is therefore non patentable. Thus, non-obviousness ensures that the patent protection is reserved for the inventions involving a genuine inventive step. That means there must be a genuine invention, genuine intellectual effort should be there to get a patent in related to that invention. Now let's talk about the statutory provisions related to the non-obviousness requirements in India. So, under Section 2, Subsection 1, Clause JA of the Patent Act 1970, an inventative step, that is the non-obviousness requirement, is defined as a feature of an invention that involves a technical advance over existing knowledge or possesses economic significance or combines the both, and which renders the invention not obvious to a person skilled in that art. This statutory definition forms the legal foundation for assessing non obviousness in India. Now, let's talk about the rationale behind the requirement. Non obviousness requirement exists to prevent the grant of patents for trivial or routine developments. Since patents grant exclusive rights, allowing obvious inventions to be patented would create unjustified monopolies, restrict the competition, and impede technological and industrial development. Therefore, this requirement maintains a balance between encouraging invention and protection of public interest. Now, let's talk about how judiciary tests the non-obviousness. The courts and the patent authorities employ several tests to determine non-obviousness. One commonly used method is the problem solution approach, which examines the technical problem addressed by the invention, the state of prior art, and whether the solution would have been obvious to a skilled person. Another approach considers whether the invention merely represents the combination of known elements producing predictable results. If so, it is likely to be regarded as obvious, and in that cases, the patent will not be granted to those inventions. Now, let's talk about certain judicial precedents related to the concept of non obviousness. There are several judicial decisions who have clarified the scope of non obviousness under the Indian patent law. Certain judicial decisions like Bishwanath Prasad Radhesham versus Hindustan Metal Industries case of 1979 in the Supreme Court held that A mere workshop improvement or trivial modification does not amount to an inventive step. The court emphasized that an invention must involve ingenuity and technical advancement to satisfy the non-obviousness requirement. Another case of F. Hoffman La Roche Limited versus Cipla Limited of 2009, the Delhi High Court examined the validity of a pharmaceutical patent and observed that obviousness must be assessed from the perspective of a person skilled in the art. The court emphasized that if prior art clearly suggests the invention, it cannot be regarded as non obvious. This case is a particularly significant in the context of pharmaceutical patents. In the case of Agriboard International LLC versus Deputy Controller of Patent, a case of 2010, the Intellectual Property Appellate Board held that merely adopting a known process with minor changes does not constitute a inventive step. The decision reiterated that an invention must demonstrate a technical advancement or economic significance to satisfy the requirement of a non obviousness. Now, let's discuss an example to better understand the concept of non obviousness and its requirement. For example, if an existing product is modified through predictable or routine changes that would naturally occur to a skilled person, such modification would be considered obvious. However, if an invention introduces an unexpected technical effort or solve a problem in a manner not suggested by prior art, it may qualify as non-obviousness and thus patentable. In conclusion, the non-obviousness requirement is a cornerstone of patent law. It ensures that patent protection is granted only to inventions that involve genuine technical or economical advancement or are not obvious to professionals skilled in the field and contribute meaningfully to technological progress. By enforcing this requirement, patent law promotes invention while preventing unwarranted monopolies. And with this, I would like to conclude my presentation on the topic of non obviousness requirements under the patent law. Thank you.